difficulty breathing, that the paramedics responded to, and they were reported to them the child had just sustained an asthma attack.
But I think you're getting into the facts. The first part of the argument, I believe what Judge Benton is asking is the second prong of the three-prong test, the product of reliable principles and methods. What are the reliable principles and methods Dr. Tulsick used in rendering his expert opinion?
Well, Your Honor, in a case where a doctor is testifying about a medical condition, the FLE's brief and the case law makes clear that reliance on their experience is appropriate regarding a medical doctor on the prong of reliability.
But if a doctor just says, I'm a medical doctor, believe me, isn't that your opinion, Ipsy-Dixit testimony that might have been okay under Fry, but is no longer okay under Culver?
Your Honor, if a doctor says that, I would agree with you that would be correct, but we would submit that that's not the facts of this particular case. The doctor didn't just say, believe me. The doctor looked at all the medical records. The doctor looked at all the autopsy records. The doctor evaluated the deposition testimony of the EMTs. The doctor came to a conclusion regarding what the medical condition was of the child, like he does in the emergency room every single day. So he applied the skill and expertise of an emergency room doctor like he would in any other circumstance in rendering opinions about what was happening with this particular child. And so we believe that in this particular case, there is reliability there. One of the key distinctions that the trial court fixates on here is that the expert only relied on the reoccurrence of respiratory distress within an hour as being sort of the drawback on the basis of his conclusions. We distinguish the cases where there's general causation because this is not about whether respiratory distress 1 caused respiratory distress 2. This is about respiratory distress 2 speaking to what was happening with respiratory distress 1. Like a doctor would do in an emergency room in any other situation. They would rely on historical facts. They would rely on the patient's, in this case, a nonverbal infant. It would be the caregivers and the witnesses who saw him in respiratory distress. They would rely on those facts to determine what the clinical condition was of the child.
To what extent can we say that he relied on the sufficient facts or data and he rejected, or at least seemed to reject, the facts, the data that EMS found on site during the first call? The witness said that the respiratory rate of 20 was possibly inaccurate. It seemed inconsistent with what happened an hour later. He said that the pulse was possibly inaccurate, and he said that most likely the lungs weren't clear. So he was unsure about what the facts were on the ground, but then his expert opinion just wholesale rejected the data that EMS had provided.
Your Honor, there's a couple ways I would respond to that. One is he did take issue with those findings in part because of the subsequent respiratory collapse. His opinion was that there was a disease process at play that essentially was obfuscated by the report of the misdiagnosis of asthma and the report by the caregivers that there had been an asthma attack. The autopsy was subsequently found there was no asthma at play here, and that's not a disputed fact here.
And this is 11-month-old.
Yes,
right?
sir.
So they don't even diagnose asthma until the child's 5 or 6.
Correct, Your Honor. And the EMT said at the scene that the child's clinical presentation was not consistent with having just sustained an asthma attack, so he didn't report that to anybody. So the doctor is applying all those different pieces of the puzzle to say that there was a disease process at play. And while he says that he disagrees that those might have been the proper findings, he was supported in reaching that conclusion because the witness said there was no physical examination of the child. And if the jury believes that disputed fact,
Well, that witness had conflicting testimony, right? She said that they used a stethoscope a couple of times.
she did, but she also said that she held the child the whole time. The child was never taken from her arms, and that the other parts of the physical examination did not occur.
Well, to measure a respiratory rate, you just watch breathing, so you don't need to hold a child to do that. And if they use a stethoscope, they get pulse. You can hear whether the lungs are clear.
But that's not the physical examination that the EMTs described in this particular case, Your Honor. They described that they took the child and that they put the sensors on him. So there's a dispute on the facts of what occurred on that particular 8-minute visit, according to even their records. And the trial court should not be in a position to weigh the credibility of the witnesses and resolve that factual dispute. that usurps the daughter gatekeeping function, and the jury should make that decision about who they believe and why they believe them based on the facts of the particular case.
But the expert's opinion, there wasn't what underlies his opinion wasn't a factual dispute. He sort of accepted what EMS said and rejected it and gave an opinion based upon he acknowledged that they did the test, but he just rejected all the data.
Well, no, he also said even if, and he was asked this very clearly, even if you assume that those findings were correct, should the child have been transported, and he unequivocally said, yes, there was a protocol applicable to respiratory distress in children. That protocol mandated the transportation of the child to the hospital. And so he still reaches the same conclusion based on the protocol of the appellee's own EMS providers in this case, which we believe is a fair, he didn't take issue with those protocols. He said that they properly applied to a child who had just suffered a respiratory distress incident. Your Honor,
Could the protocol be the reliable principle and method? So he's saying there's a protocol here that was not followed. Could that be the reliable principle and method that he's comparing to? I'm following you on step one. He can choose which set of disputed facts to believe. But nowhere in Dr. Pulsick's deposition is the word principle or method mentioned at all. So how do you get over step two at all? Is what I'm trying to find.
well, Your Honor, we get there, again, if you look at the federal case law, and the guise that expertise is particularly relevant and goes to reliability when it's a medical doctor describing a medical condition. The Ninth Circuit said that in 2010. The 11th Circuit said that in the Adams case. So we get there, and I would answer your question in the affirmative there. His reliance on the protocols of the EMT providers themselves, similar to a case where a defendant's own breach of their own standard might be evidence of negligence. Here, the defendant's own standard mandated transportation for a child who had just sustained respiratory distress, that is a proper application, a reliable application of the principles and methods of an emergency room doctor to the circumstances and facts of the case.
And isn't that the core issue, whether the child should have been taken to the hospital so a doctor can look at the child or given oxygen? Wasn't that really the question, more than the precise cause of the child's death?
Yes, Your Honor. We believe that that is the breach of the standard of care. The fundamental opinion here on the breaches of the standard of care is that the definitive protocol mandated transportation to the emergency room. And we also had a forensic pathologist who was not attacked in this case say that the failure to transport him was the cause of the child's death, independently of this particular expert.
Dr. Anderson?
Yes, Your Honor.
So that affidavit was in the record, it just not mentioned by the trial judge.
Yes, Your Honor, and his deposition was also in the record. And he was opposed on both what he thought was the cause of the child's death and on the survivability opinion. That if he would have been transported, he would have survived the second respiratory, or he would not have sustained the second respiratory incident, he would have survived the first respiratory distress incident.
And that's the issue, regardless of what caused the respiratory distress, you contend.
Yes, Your Honor. That's the key issue in the case, and that's the key standard of care opinion of the expert in this case. Your Honor, we also believe that the court erred in not allowing us to supplement the expert's opinion. This court, when a panel considered the Dauber issue, I think on the only time it's been considered by this court, in Booker said that the purpose of the Dauber objection was to allow both the counsel to have the doctor address the perceived deficits in his testimony. We specifically requested that at the Dauber hearing, and the trial court, in excluding the expert, rejected allowing that to occur. We believe that was error in this case, and for that reason alone, the trial courts should be reversed. And based on these arguments, we believe that the expert was qualified to render the opinion, and we ask the court to reverse remand this case for a proper application of the Dauber standard. Thank you.
May it please the court, my name is Miriam Cole. I'm here with Victoria Penny on behalf of Columbia County. Today, we're asking this court to affirm the trial court's grant of summary judgment in this case based on the exclusion of the testimony of Dr. David Tolsiak. The primary issue...
So you agree that if the evidence had not been excluded, summary judgment would have been inappropriate?
Yes, Your Honor.
So what do you do with the Anderson affidavit and deposition?
The summary judgment was only as to the standard of care, and without the standard of care opinion about any evidence of a breach of standard of care, which is why they need Dr. Tolsiak, they could not sustain their cause of action. The summary judgment was warranted as plaintiff's counsel conceded. The issue here is whether or not the court abused its discretion in determining that the standard of care opinion made by Dr. Tolsiak was unreliable, not making sufficient factor data, and unhelpful. Now, Dr. Tolsiak's standard of care opinion, 10 times in his deposition, he supports that standard of care opinion with the fact that the child was in respiratory distress. And so because the child was in respiratory distress, he should have been transported. He gets to that because of the fact that the child had a respiratory arrest an hour later. There's no other evidence.
Well, if the neighbor saw the child in respiratory distress, do you read the record otherwise?
Well, first, Dorothy Benoit testified that she believed the child was in respiratory distress because he was turning red. That was the sole basis for her belief that he was in respiratory distress. She said he never stopped breathing, and that by the time EMS arrived on the scene, he was fine. But most importantly, Dr. Tolsiak never relied on any testimony by Dorothy Benoit in rendering his opinions. What he relied on was the fact that the child subsequently had a respiratory arrest. And because the only evidence in the record of what the child's condition was...
He relied on her original recorded statement, right?
Well,
you're distinguishing between that and her testimony?
Yes, he never relied on the affidavit or the deposition. In his deposition at the very beginning, he did testify that in 2010 he was provided all of the recorded statements, he read them, he relied on them. But in the 100 pages of deposition testimony, where he specifically gives the basis for his opinions over and over again, he never once said that he relied on anything that Dorothy Benoit said. He never gives that as a basis for his belief that the child should have been transported or that the child was in respiratory distress. This is kind of an after-the-fact indication.
The EMT thought that the child had been in respiratory distress, right? Isn't that why they took time to go over how the nebulizer worked with the person who was taking care of the child?
The EMTs respond to a call. They're told by the dispatcher what the layman on scene believes. They could be told there was a heart attack and they get there and they find it was a stroke. So they respond to the scene with the idea that there's respiratory distress. They get there, they're told that the child's fine. They do an evaluation. The guardian asks them about the nebulizer and they show her how to use the nebulizer.
By the way, I think the record's clear that there was a history with this child of respiratory distress.
Well,
Is that something that EMTs were aware of?
Yes, the guardian told them, I thought she had an asthma attack because there's a history of asthma. However, Dr. Tolsiak, in rendering his opinion, completely discredits the history of asthma and says the child doesn't have asthma.
And yet I believe he also said that there must have been a history of some kind of respiratory problem that was mistaken for asthma.
Yes, that is his assumption. So basically that history of asthma and the fact that the child has a respiratory arrest an hour later is the sole factual basis for his diagnosis, essentially, that at the time that EMS was there, the child was in respiratory distress. The only evidence of the child's actual condition at the time is the evaluation findings of EMS. So because those are inconsistent with the
How did they get that oxygen saturation reading? Her testimony, her most recent testimony, they didn't do anything. It is true that in an earlier statement she said that while she was holding the child over her shoulder, they put a stethoscope to the child's back. That doesn't give you the saturation level.
That is true, Your Honor.
She said that was so the best thing you've got going is that she used the stethoscope. So where does that number come from? Because that is that's been suggested that these numbers were made up after the child died less than an hour later.
That has been suggested, and so that is...
By the way, what is your theory of you had an expert that's going to say that the child was slammed against the wall or something, and that's why the child stopped breathing?
Well, to address your first point, Your Honor, yes, there is a conflict in the record of whether an evaluation was performed. However, that's not relevant to the exclusion of Dr. Tolsiak's opinion, because Dr. Tolsiak believes that more than a cursory evaluation was performed. He does not dispute the fact that an evaluation was performed on this child. So while at trial that might have been an issue, it's not an issue as it relates to the exclusion of Dr. Tolsiak's testimony, because he believes an evaluation was performed on the child. As to what the defense theory is that the child sustained a brain hemorrhage as a result of some type of trauma. The medical examiner observed it, and so did the medical examiner who did the brain autopsy. Neither of them could rule out head trauma as a cause of the child's death. That's another evidence in the record. Dr. Tolsiak says he relies on the medical record.
examiner did rule that out.
She did not rule it out. She said she could not determine whether it was the cause.
I thought she was talking about the pneumonia.
She
That
didn't.
She said maybe the pneumonia was because the child eventually ended up on the ventilator.
She said she could not rule out trauma to the head as a cause of the respiratory distress, as a basis for the child's death.
Well,
And
if that's the issue, which I think we're a long way from the real issue in the case, but if that's the issue, Dr. Tulsiak said just the opposite.
Dr. Tolsiak did say just the opposite. What Dr. Tolsiak did is he does not, under the reliability prong of Dahlberg, he also has an obligation to address alternative theories as to how the child died, and he doesn't address it. He acknowledges that head trauma can cause respiratory distress, but he doesn't see it here. He did not reasonably explain why head trauma was not the answer in this case, and why instead his artificially created respiratory distress because of the respiratory arrest was.
Artificially created respiratory distress. The EMTs are there trying to set up the nebulizer and so forth, and then another neighbor finds the child dead, essentially, and mucus everywhere and fluids. What's artificial about that?
With regard to the mucus, his testimony was there were copious fluids. Both the medical examiner and the EMT say that upon death, a mucus or vomit is emitted, and that is probably what those copious fluids are. But again, Dr. Tolsiak did not rely on that in reaching his opinion. Dr.
I
Tolsiak.
think that neighbor who had EMT training said mucus and.
He said mucus and fluids. What he said, the copious amounts of fluids he saw matches what EMTs later say is vomit, and that matches what the medical examiner said, which is stomach contents, because the child had died. And Dr. Tolsiak agreed when he discredited the bronchopneumonia. He discredited the bronchopneumonia, but he also said that happens, that upon death you can vomit, your stomach contents come back up. And so that explains.
But now, all of these fine details are a long way from the question of should the child be taken to the hospital and have a doctor look at it.
Yes, Your Honor. The basis for his opinion that the standard of care was breached and the child should have been transported is because he was in respiratory distress. There's one time in his deposition where he said, even if the vitals were true, you should still transport. But he turns around on page 50 and 55 of his deposition. He's asked, and the reason you should transport is because the child is in respiratory distress. Yes and yes. In addition, he never gives any type of reliable basis for that opinion.
On page 45 and 46, assuming the respiratory rate 20, pulse 120, if you assume those things, was the evaluation appropriate? Answer no. Why not? Because there should have been another assessment done. There was an initial assessment, agreeing with what you said, but there should have been at least a second assessment, a longer assessment, a more detailed assessment. So whether EMS did that longer assessment there on scene, or whether the child was transported to the hospital, isn't Dr. Tolsiak saying the standard of care was breached by not a second assessment occurring somewhere?
Yeah, a little bit farther down in his deposition, he said that breach of the care, standard of care didn't matter because he should have been transported anyway. And then on page 50 and on page 55, when you ask him why he should have been transported, it's because the child was in respiratory distress. So his entire standard of care opinion hinges on his assumption that the child was in respiratory distress at the time EMS was there. With regard to the protocol, as being some type of basis for a standard of care opinion, He himself testified that the protocols are guidelines that the EMT has to look at the situation when they arrive and determine whether or not the protocol should be implemented, and that they can not follow the protocol if there's no question when they arrive on scene. And so what he really does is he disagrees with the paramedic's judgment on the scene. However, he does not provide any reliable basis for
That's
reaching
what
that
we were
standard of
talking
care.
about, isn't it? It's a question of judgment, not a question of scientific causation. We're talking about a question of judgment. We're talking about should the child have been taken to, so a physician could examine the child, and should oxygen have been administered?
Yes, and Your Honor, under Dahlberg, every expert, whether they're an engineering expert or a medical doctor, has to have a reliable basis for their opinion. That is not pure opinion.
Well, it's not her opinion. He points to their own protocol.
But the protocol doesn't say what he said it says. The protocol doesn't say you have to transport. It basically says the paramedics have to use their judgment. And if they find respiratory distress, then they have to transport. But there has to
So
be their judgment.
The protocol hinges on there being respiratory distress when they arrive.
Yes, and so the paramedics have to make that
So
assessment.
if there's not respiratory distress when they arrive, the expert said that he still needs to be transported. Did he reference a protocol that applies to that situation?
Only that one protocol that he then says is just a guideline, and the paramedics have the ability to disregard it if there's no question when they arrive on the scene. And then he goes and says, well, basically, I think their judgment was wrong. They used their own medical judgment and it was wrong. But he does not provide any basis for that. Essentially, all he wants us to
Doesn't he
do,
do essentially a differential diagnosis? I mean, the question is raised to him, wasn't this the result of a brain hemorrhage?
one,
And he said no.
Dr. Tolsiak never did, there's no evidence that he did a differential diagnosis. He didn't say that he did a differential diagnosis.
He considered that possibility.
He considered when asked in the deposition. He did not start with a list of 100 things it could be and then narrow it down to respiratory distress, and that's what a differential diagnosis requires. But even in that context, he is required to have a reliable, objective, independently verifiable basis to explain the methods and principles by which he reaches that standard of care opinion. This is similar to the case in Dukes as well as...
What do you say to his argument that, hey, we asked for an opportunity to develop that?
Your Honor, twice, the trial court in this case gave much consideration to these issues. We had 2 hearings and we had proposed orders. The trial court asked him, what would you add to supplement? And never once did plaintiff's counsel say he's going to change his opinion or he was relying on this and that's what he's going to testify to. What he said is if there's any confusion about the bases for his opinions, I want to clarify those. But there was no confusion in the deposition as to what the basis for Dr. Tolsiak's testimony was. They had ample time during the 10 months from the deposition to the motion to exclude to supplement the testimony based on new findings or anything that they never did. And the reason is because Dr. Tolsiak was clear in his deposition that his opinions were final, that he had every opportunity to articulate his opinions and the basis for them. So there's really nothing that they could do to salvage Dr. Tolsiak's testimony. In addition, with respect to the timeliness issue, in Booker, that case deals with workers' comp cases. Procedurally, this case was in the same posture as half of the Dahlberg cases that we relied on, including Perez, where you have motions to exclude the expert around the same time as summary judgment. There was 2 months before trial in this case. The court had ample opportunity to consider those issues, and he did so. He did not abuse his discretion in determining that Dr. Tolsiak's entire testimony, when you boil it down to what Dr. Tolsiak was saying, it's because this child was in respiratory distress, they reached the standard of care not transporting, and that's because of the respiratory rest. It's that whole temporal proximity, the post hoc ergo propter hoc.
Would you consider stopping breathing? Would you consider that respiratory distress?
Stopping breathing. The issue is whether or not the child was in respiratory distress at the time of EMS's assessment of the child, because that's what Dr. Tolsiak's opinion
Wasn't
relies
there some
on.
discussion about bronchospasms? In other words, something that could come and go. And can we just ignore the fact that the caretaker was so distraught that she ran to the neighbor for help because of the child's breathing?
That is certainly a fact factors should be considered, but that is not sufficient facts or data to render a diagnosis of respiratory distress at the time of EMS's assessment of the child. And that's essentially what Dr. Tolsiak has done. That is not the subject of expert testimony. That's pure opinion under Florida law. And it's basically the same thing that the plaintiff's attorney can get up and say in closing. What an expert has to do is provide scientific analysis to explain scientifically what is going on here, and then defend that science with reliable objective methods.
The child died within the hour from lack of oxygen.
Right, so that is the same as like in Perez, where you've got something bad that happened, so we can assume the standard of care was breached at the time because of this bad things that happened afterward. You have to have more than that. And that's essentially all Dr. Tolsiak relies on is this temporal proximity. He doesn't explain it scientifically. He doesn't come up with...
Well, he says he's been doing this for 30 years, or 25 years, and that he has seen hyperactive airway disease, bronchiolitis, congestion, pneumonia, upper respiratory tract infections, bronchospasm, and other respiratory conditions. This is not a TV commentary.
The Florida legislature has expressly said that is not enough. Pure opinion, as authorized by March, is no longer good. It is.
I think that what happened is under Fry, that that expert opinion got a buy. In other words, wasn't tested, even under Fry standard. And now it is, you're absolutely right, that under Dobbert, even pure opinion has to be tested, but what if they don't have it?
Your Honor, I've exceeded my time. May I just say one last thing?
Briefly.
Okay, this is like the first district of court's opinion in Giamo. In Giamo, you've got a treating physician, the treating neurosurgeon, who renders an opinion, and he reviews all the medical records. He clearly has plenty of expertise, and the court says, you just saying it based on your expertise is insufficient. You've got to have something else. You've got to have literature. You've got to have studies. You've got something objective to show me why your opinion is reliable. And for all these reasons, we believe the trial court did not abuse its discretion. Thank you, Your Honor.
Thank you, Ms. Phillips.
Your Honor, the application of the respiratory distress protocol clearly applies to an infant who has 911 call after suffering respiratory distress. To the extent that's an issue of fact, that belongs the subject of expert testimony. When it applies, why it should apply is exactly the purpose of an expert who can opine on the EMS standards that are applicable to the case. He's familiar with the protocols. He's been involved in developing those types of protocols. So saying that they don't apply because the child has suddenly improved their condition is a matter for the experts to talk about and doesn't defeat the true condition of the child or the clinical presentation of the child as having immediately before sustained respiratory distress.
How about his answer on page 55 of the transcript? The implementation of this protocol is based on the assumption that he was having respiratory distress at the time of the first call. Correct. So it seems like the expert's opinion was based upon the protocol being coming into play if there's respiratory distress when EMS shows up. Is that correct? Am I reading that correct?
Well, Your Honor, you're reading it correct, but I believe that that's construing it over narrowly. The presence of respiratory distress moments before their arrival, which is relayed to them, which is a purpose in their own record of their response to the scene, which is the asthma attack described to them that had just occurred, even though they said that clinical presentation was not consistent with an asthma attack. Though that's the respiratory distress that implicates the application of the protocol.
So we're talking about the same protocol. That's not a different protocol, but it's the same protocol that he's addressing.
Yes, Your Honor, it's that same protocol.
What about her argument that property record protocol just says that's a baseline and that EMTs are entitled to not to transport if they, in their judgment, the child is breathing all right?
Well, Your Honor, I think Dr. Tolsiak was a little bit, and did say clearer that that judgment was not properly applied here. They didn't reassess the child, as was noted a few moments ago. They also proceeded to give the child a nebulizer treatment which, interesting, is a part of the respiratory distress protocol that is taken out of context and not completely followed, administering a medication to a patient upon responding to a 911 scheme. So they didn't follow that protocol because that requires waiting for the administration of the medication and reapplying it if necessary. They didn't do any of those things. So they sort of applied the protocol, and the application of the protocol is designed to remove discretion from the EMTs and give them a standard to apply when there's life and death decisions at stake. That's what occurred here. A child died because he wasn't taken to the hospital. And that's clearly what occurred when you have two respiratory distress incidents within an hour of each other. Your Honor, the court finding that the true facts of what the child's condition were only as those documented by the EMTs, really we believe is a key fundamental error, because the jury should have been able to determine that the witnesses were reliable, that he did sustain breathing difficulties, and had they found that, then the child, the opinion the child should have been transported would have been properly admissible. So again, we ask the court reverse and remand for proper application of the downward standard in this case. Thank you.
All right, thank you, Mr. Alba. We're going to be in recess at this point for a very